Hello, my name is Howard Cohn, and I'm the founder and principal patent attorney of Howard M. Cohn and Associates. I would like to welcome you to another segment of our video blog series about protecting your intellectual property. This video is entitled Avoiding Patent, Trademark, and Copyright Problems. Patents, copyrights, trademarks, and trade secrets are collectively called intellectual property or IP. As you already know, patents and other intellectual property are important to achieving market success, but do not guarantee it. Clients are often tempted to avoid investing their valuable startup capital in IP-related expenses. Yet, it is dangerous to defer these costs. Infringement of another's goods or services poses financial risk even if it is accidental. Moreover, it is important to at least know how to cost-effectively protect your intellectual property rights. Let's assume that you've invented a better can opener and intend to initially make and sell it yourself on the internet and at trade shows. If available, filing a patent on your idea could hinder your competition while your product is launched and therefore warrants careful consideration. However, let's assume that you don't want to spend money on patent protection. Brand names or trademarks are also helpful in marketing your can opener. Being aware that good brand names command premium prices, you pick Top Off as an easily remembered trademark. Then, finding the mark unregistered in your state, you register it yourself for a modest fee. The more success you enjoy, the more others will be tempted to copy the can opener. What will happen if the can opener becomes so successful that a large, well-known competitor copies your product and sells it for 20% less? Consumer goodwill towards Top Off may be enough to meet that level of competition. But what will happen if others later prove to have superior rights in Top Off or in some feature of your can opener? Having ignored IP concerns, you might have to buy expensive licenses or, possibly worse, forfeit your trademark or preferred design. So how can you avoid some of these problems? First, let's consider avoiding patent problems. You don't have to produce an exact copy of a product to infringe on either a utility or design patent. Utility patents cover how a product, such as the can opener, is made, operates, or is used, and can halt the unauthorized practice of the patented can opener for approximately 20 years. Design patents protect the appearance of a product, such as the can opener, and can stop the use of a similar design for about 14 years. Infringement of either a utility patent or a design patent can result in money damages or being prevented from making or selling your can opener. The only way to discover potentially blocking patents is to conduct a patent search. You cannot assume that because you don't see your can opener on the market, it is unpatented. In many cases, patented products may never be sold or soon fail after being introduced in the market. If the patent search turns up an unexpired patent or pending application, you'll need permission to use it. Ignorance of infringement is not a defense, and injunctions can mean legal fees, inventory loss, and retooling costs. Let's turn to avoiding trademark problems. Trademarks or brand names, including words, slogans, and logos, are used to indicate the source of your product. A special advantage is that trademarks do not expire, and the longer they're used, the more valuable they become. Unlike with patents, delay before seeking protection is less apt to be fatal. Copying another's trademark is unwise because you can be stopped from using the mark and lose your investment in time and money. For infringement, there is no need for your mark to be identical to another's. It only requires likely consumer confusion. Trademark searches are critical to keeping hard-won goodwill. To use Top Off without learning whether that name is already used by others on similar goods is risky. First, internet knockout searches should be done using Google, for example. Marks that survive should also be checked against state and certainly against federal registrations and pending trademark applications. No one is eager to use precious startup capital for patent and trademark searches. But proceeding without them is like erecting a building without clearing the real estate title. In sum, patent and trademark searches help ensure enjoyment of hard-won market success and offer comparatively cheap insurance against the risk of retooling and the loss of inventory and advertising costs. Let's move on to avoiding copyright problems. It would be a very bad idea to copy others' text, drawings, or photographs without permission or advice of counsel. However, copyrights are not apt to be infringed without conscious duplication of copyrightable subject matter. Exclusive rights to reproduce protectable subject matter arise automatically, and copyrights last for very long periods of time. While not being required, prompt copyright registration is inexpensive and offers attractive remedies. Now, let's consider protecting your trade secrets. Most competitively valuable information, such as customer and supplier list, is, if kept secret, automatically protected from misappropriation. You and your employees must be careful to preserve the confidentiality of all such information. Despite such efforts, you should understand that without patents, others may copy anything you market. The bottom line is that few people starting a business have much knowledge of intellectual property. The more money or time you plan to invest, the larger the potential cost of ignorance. The best approach is to retain experienced patent and trademark counsel. We have over 35 years of experience in all aspects of intellectual property law. If you have any specific questions or would like to schedule an initial free consultation, don't hesitate to contact us by phone or through our website. Thank you for listening to this segment of our video blog series about protecting your intellectual property. I look forward to speaking with you.